You want to settle your case shortly after you started. You went to the best attorney you could find who confirmed that you have a valid basis for a case. And now, at the very beginning, you tell your attorney, listen, I don't want you to drag this on. I don't want to go through the entire litigation process. I want you to settle this case as soon as you can because I don't want to deal with the entire litigation process. And your attorney turns around and asks you a quick question. How do you know how much the value of your case really is right now? And you are dumbfounded. You don't know how to answer that question. You want to know what this is all about? Come join me as I sit here in the car waiting for my wife as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. You want nothing to do with this lawsuit. You are aggravated. You are frustrated. You are feeling helpless. You are sitting at home every single day wondering why you are in so much pain, wondering why you are disabled, wondering why you can no longer work, and why your life has been turned upside down. And now, after going to an attorney who confirms, after many months of investigating, who confirms that you have a valid basis for a case, you tell your attorney straight out, listen, I do not want to have this protracted. I don't want to have this dragged out. I don't want to have to go through the entire litigation process and give this thing called a deposition. I don't want you to go ahead and question all these other doctors. I want this done as soon as possible. And your attorney turns around and says, okay, if that's true, tell me what you think your case is really worth. And you don't have an answer. And your attorney says, you know what? I understand your frustration. I understand that your life has been turned upside down. But at this early stage in your case, we don't know what the true value of your injuries are. If we don't know, how can the defense know exactly what they are? And how can you expect them to offer up money if they don't understand the true value of your injuries and the full extent of your injuries, as well as the extent of your disabilities? If we don't know it, then certainly the defense isn't going to know it, and they're not going to offer a single dime until they do. And importantly, they're not going to make any such offer until they recognize that they have significant problems with liability, meaning that it's clear and obvious that the doctors and hospital staff violated the basic standards of medical care, causing you significant harm and injury. Until they begin to recognize that, they will never offer a single dime until they understand that they have to pay in terms of a settlement or by verdict. If we are unable to show to the defense that we are slightly more likely right than wrong than what we are claiming is true, that the doctors and hospital staff violated the standards of care and caused you significant harm and injury, then they will never go ahead and make an offer to you to try and settle this case. So there's an entire process that goes into getting the defense to recognize that, number one, they are liable and responsible and have to be held accountable for your injuries. Number two, that the wrongdoing was a cause of your injuries. And number three, that your injuries are significant and permanent. So at the very beginning of your case, it is literally impossible to know the full extent of your injuries. You may need additional care and treatment. You may need physical therapy. You may need additional surgery. And now, as you try and improve yourself, your medical condition, your doctors may tell you, listen, you have exhausted all of your medical options. The only option may be surgery, or you may have no options whatsoever. You're going to have to live with this condition for the rest of your life. At the beginning of your case, you may not know that, and your doctors may not know that. So as much as you may want to try and resolve this case early, as much as you clearly don't want to go through the litigation process, to get to that endpoint where the defense makes a substantial offer that you seriously consider, you can't get there until all of these details are known. And at the very beginning of the case, there is no possible way that your attorney is going to know those details. It's unlikely that your treating doctors are going to know those details. And if your attorney doesn't know them and your treating doctors don't know them, how can you expect the defense to know them so that they can make an educated decision about how much money to offer to try and settle your case at an early stage? So why do I share this quick information with you? I share it with you because it's critical to understand. As you begin the lawsuit process, I understand how it's so difficult to recognize that you want this done and you don't want to have to go through with it, and that's perfectly understandable. However, to get to that end point where the defense now makes a substantial settlement offer and you are seriously considering it, the only way you will get there is if you and your attorney have done a very good job detailing and explaining in depth why they are responsible and why that carelessness was a cause of your injuries and why your injuries are so significant and permanent and disabling. I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.